gather once more to deliberate on this important piece of legislation, proposed legislation. We invite your presence. We ask you to, as you have been doing, to take control of the proceedings, that everything will be done to your name's honor and glory, that we will accomplish fairness, good balance towards the betterment of our nation. Guide us, we pray, for we ask it in Jesus' name. Amen.
So, my friend, yeah, look like you're really getting near the deacon's job. Seems to be occupied for quite a few retired people, so they're ready for you to retire yet, but to get the training. Any apologies for absence? Okay.
Sorry, Chair, good morning. Down here. Good morning. Members, just to advise that Director of Legal Reform, she's on her way, but she'll be a little late.
Sure. Thank you very much.
Not so good in the carpet, but I'm here. Thank you.
Thank you. No. All right. Keep well. Thank you.
And Chairman Senator Campbell Bowling will be here, but a little late. She has asked me to convey her to the committee.
Then we have a quorum, full quorum. Mr. McCarthy, Mr. Charles Gibbs saying he doesn't get emails, but I think with his, we might have to look seriously how many ministers we invited to this panel, get some more of our parliamentarians involved in the legislative process. Where are we now, Minister?
Chairman, we concluded at clause 72, and we are to resume at 72, the subpart obligations of holder of firearm authorization.
73, registration of firearm. 1, the holder of a firearm user's license, firearm user's business license, or firearm user's restricted license shall, within the time specified in subsection 2, submit to the authority for registration the firearm to which the license relates. 2, the firearm shall be submitted under subsection 1 within the period of 30 days immediately preceding each birthday of the license holder. 3, if on inspection of a firearm submitted under subsection 1 for registration, the authority is satisfied that the firearm is in good working condition and has not been altered in any way, and that the holder is a fit and proper person, the authority may issue a certificate of registration in the form prescribed upon payment of the prescribed fee. 4, a certificate issued under subsection 3 shall be valid from the date of issue thereof until the next birthday of the license holder. 5, any holder of a license to whom subsection 1 applies who contravenes that subsection commits an offense.
Mr. Chairman, we again have this provision about the holder being a fit and proper person. And I still ask if some clarity can be given to that. I've seen in practice persons going to do their registration of firearm, and their firearm is held on to by the authority, and in some, under provision to say that they are subject to some type of investigation without any specific clarity being given to the firearm holder. And in some instances, eventually they are served with a notice of revocation with a very short phrase as to the reason why they would have the revocation notice is issued. Sometimes it says that you are not a fit and proper person, and the person just cannot appreciate what that in fact means, and there is nothing that is given by the authority. The person is then subject to making appeals, and we have seen in recent times where the appeal fee has been increased by 400%. The person, the firearm holder, the previous firearm holder in the circumstances submits his appeal with little information, save and accept just saying, I'm a fit and proper person, so why revoke my firearm? There's nothing that they can say otherwise, because this provision is, or this term, there's no clarity to it. And then when you go to the review board, or you make the appeal to the review board, there is no response from the review board. Persons have been waiting for an extraordinarily long period of time. I also have a concern with it for the fact that a person is issued with a firearm by a previous board, and in the interim, until they receive that revocation, they may not have committed any particular breach of the Firearms Act regulations, but then find themselves in this precarious position where you are told that you are no longer considered a fit and proper person with no substance to it, and then burdened with the fees that are involved in making the application and really not getting anywhere. I think this term, it either has to be clarified, or there has to be some requirement for the authority to provide to the holder. And it cannot be that it is confidential, as I said, to the holder. Exactly what reason or reasons you may find yourself subject to not getting your firearm registered with this term being used. And it also opens the authority to be, or the board, to be reviewing the position of the board, of a previous board, a previously properly constituted board that gave a person a firearm permit. So without more, as I said, in the interim, this term is being used, and I think it has been used against persons in a manner that prejudices them immensely. So I think some clarity needs to be given to it.
Thank you, Senator. I want to invite the Minister, or the Mr. All right, from Mr.
All right, Minister.
Because fit and proper in terms of a term, before we come in, I need legal comment there, because it's a term I've come across in many years of government. Legal areas. It's not anybody at the board of a financial institution, government. In fact, I think all the larger boards are going to have it included. If you have to be a board member of HART, NHT, Bank of Jamaica, the term uses you have to pass fit and proper test. So before Mr. Darling come in, this is the board, I'd invite my minister to make a comment on the issue.
Sorry. I suppose in those circumstances, there is something that leads you to the use of the term. So you may have it being speaking about whether you are a person declared a bankrupt, whether you are involved in matters that relate to dishonesty, and so forth. And then it comes to the broad term fit and proper. So if you use a principle of statutory interpretation, which I refer to briefly as you just them generous, you can appreciate it when you come to use broad terminology after you set out certain specifics. But I don't see it in the legislation, and it is what is creating a lot of issues for persons.
Still, I had Minister to comment. I'll deal with the appeal in a little while later, because there's a process that we're taking. There is a challenge with the appeal process, which I'll comment on before we go there, but I invite the Minister to.
Well, Chairman, the if we go back to clause 58, and you see the criteria that are set for the grant of firearm authorization by the board, you see both the disqualifying provisions and the qualifying provisions, and fitness to hold a firearm will have to be construed in this context. No, I think the clause needs a little rephrasing. So there is an ongoing duty on the authority and the board to be satisfied that the holder of an authorization remains fit for the duration of the authorization. But I think the section needs to be reworded a little bit, because it is dealing with the obligation to turn in the firearm to ensure that it is checked, and that the obligations here are referred. So under 58, it speaks to the applicant is a person who can be in possession of the firearm and ammunition without danger to any person or to the public or to public safety. As to the applicant's proficiency in the use and management of the type of firearm in respect of which the application is made, and the adequacy of provisions for safekeeping of the firearm and ammunition, and the residency provision. But when the holder turns in the firearm at this time, the holder is already licensed, and it's really a certificate in respect of the condition of the firearm that is there. So I think the clause has conflated some issues, but you can invite a comment from the authority, and I'll come back to it.
They have to give a practical application.
Yes.
It's a legal term they need to authorize, because they have instruction and they carry that out. I think the qualification, fit and proper, has to be, is technically a drafting and legal comment. You know.
So the fitness, so remaining, the person being fit and proper would have to be remaining fit and proper for the continued holding of the license, really.
Mr. Dan.
Yes. Thank you, Minister. Minister, let me explain the practicality of the clause. The FLA carries out continuous checks on all license holders. Although the license is valid for 5 years, we continuously get intelligence report and carry out investigation on the holder. So when the holder comes in for the registration on an annual basis, we check the criminal record of that individual. We are connected electronically to the criminal record database. And so when the person comes in for that registration, we also run a background check on the individual. So in between the last registration of the firearm and the next, if the person commits an offense for which he has been sentenced, or there are intelligence reports coming in on the individual that he is involved in criminal activity, at that time we use the opportunity, Minister, to
I don't think the member has have an issue with that. You know. That is quite clear.
Right.
What the member is talking, which I said, I need the comments of my legal, is the all-inclusive clause is fit and proper. It has to do with whether clearly if a person reported to the Firearms Authority based on current investigation or activity in the last 12 months, it will be dealt with accordingly. What the member is concerned about, as I said, is the all-inclusive term fit and proper, which comes in a number of issues. Is it the right thing to use in the case of a firearm FLA? Because that's what you, it's these all-embracing terms. And I know there's a legal term for it, which you use, whether it is a financial institution or some institution of a certain level within the government service. So I'm saying, so what you're saying there is accepted. It's not a dispute. It's whether we should use this all-embracing concept of fit and proper, and how do you explain it to the clients who are affected?
Mr. Chairman.
I think Mr. Bailey, you're trying to comment here.
Mr. Chairman, the client is aware, because at that opportunity, at that time, we invite the person to respond to the allegations, and usually there's a written statement taken from the individual responding to the allegation that I made.
You're walking a trouble road, Mr. Darling. I've been there already. You're not understand what I'm saying. But you hold it. Have to be able to comment. In policy.
Yes, Minister. The point I was making it in support of what Minister Ford would have said just now in terms of the interpretation to be given to fit and proper, that it's understood in the context of the legislation. And because we would have outlined the circumstances or the conditions that an individual must fulfill to be deemed fit and proper for the purposes of an authorization, that is how it will be interpreted. I understand that there may be some necessity in providing some further clarity, whether or not we're going to make reference to clause 58, for instance. That's a consideration. Or simply, as Minister Ford was suggesting, changing the language to an extent to signify that what is considered is whether or not the individual remains fit and proper for the purposes of the authorization.
You seem satisfied with that?
Yes, Chairman, because the law does set out what amounts to fitness and propriety to hold the firearm. So you wouldn't be, you're not a person of intemperate habits, you're not suffering from mental disorder.
There should be a reference back to that. There should be somewhere.
Yes, it would need to make reference to the criteria set out at 58, 3 and 4.
There's otherwise unfit to be interested with such firearms.
Yes.
There are quite a few series of activity there in 58.
Right.
Senator, would that satisfy your?
Yes.
We can put it right. So there is their framework which you're referring to. Yeah. I just want to, before I move on to 74, identify that, recognizing that there's been a major problem with the appeals, which has been the source of number one, not just a matter of minister intervening. There's a backlog for many, many years, which I think, which we are now undertaking to clear up. That is where I may come, Mr. Darling. How far are we now? I know they've been proceeding on a weekly basis pretty rapidly. Where you passed 2021, you reached 2021 yet?
No, Minister. We're in 2020.
Right.
But they're meeting more often now. They've met twice last week, and so they're moving apace to clear the entire backlog.
The real challenge review is, as I said, they have increased the fee, and when we did, an attempt was made to clear the backlog, and then realized so far back still. So the object is to clear the backlog, which are based on old fees anyway, and get current. And this is why I think further in the bill is, Senator, we have added that we would give them 6 months to respond. If they have not responded in 6 months, then you can get a court order, and to have this review panel review their issue immediately. Or if there's a dramatic change in circumstances, we make the request for urgent review. But the object is that by the time this law is in place for activity, we'll have cleared the backlog. There's some administrative arrangements were made. I won't go into details, but there's supposed to be administrative arrangements in place to allow them to keep meeting 2 to 3 times a week to clear the backlog.
Just wanted to interject here through you, Mr. Chairman, in relation to the concern earlier in Section 58 and 72 together. Is it now, if it is that we modify the Section 72 and refer to 73, my apologies, 73 and refer to 58 in terms of defining clearly the fit and proper criteria, would obliged to specify directly, to state clearly in the revocation letter exactly the reason for the revocation. So let's say, for example, it is discovered that you have since been granted a license, you have been charged, with a domestic violence offense, or you have been involved in a drug habit. Is it now that in revoking the license when you go to register, the letter will state that specifically so the person now can answer, be in a position to answer to that? That's just a question I'm raising.
It will not be It can be made a requirement. There are circumstances where the person will have to, if they want to have the reading, they'll have to get judicial review and they indicate in the session. That's the minister just was raising. You want to comment?
Chairman, the authority in the exercise of its function, if it takes a decision adverse to the holder of the authorization, would be required to give the reason for it. The extent of the reason, and it must be enough to enable the holder to know why a decision adverse to him or her has been taken. That is just the standard that is required in the discharge of statutory functions by a public authority.
And that is laid out at clause 84.
Just in clause what? Clause what?
Center Golding.
Clause
Center
what?
Sinclair.
You said clause something.
84, clause
84?
84.
Minister Malahou.
But here we go again with 84 that is speaking about is otherwise unfit to be entrusted, and which is the same provision which is in 58, otherwise unfit to be entrusted. It is just, it is vague, very vague. I think, and why I'm going to, in response to Minister's comment, that when you look on the court decisions that have dealt with this situation, it is the position that the authority does not have to do more than just say, you're not fit and proper. Or we don't consider you, we don't provide the reasons. The decisions that we have that have gone before the Court of Appeal speaks to the review board is where you are entitled to get the information so that you can have a fair hearing. But when the person is submitting their application for review, they are operating in a blind fashion. They don't have any understanding why it is that their firearm may have been revoked, or in circumstances, which I will also ask you to address, Mr. Dallin. The FLA is also taking persons' firearms, saying that they are subject to investigation, and 3 years investigation not even concluded, and the property of the individual is being held by the authority, and it is property, and people have constitutional rights to their property. And I can give you specific examples, situations that have arisen like that. All right? So I believe, having regard to the decisions in the court, that if you are saying a person is unfit to be entrusted or not fit and proper, that the authority should be required in the statute to set out to the individual sufficient specifics so that they can, for themselves, determine whether they are going to incur this significant increased fee of $50,000 to submit an appeal. They may say, well, look here, I'm not going to bother because I'm not going to be able to, right? Or, yes, based on the information that has been given to them, and it can be confidential to the individual, it is them. It is not a third party you're passing it on to. It is the individual. So, Madam Minister,
let's look on the scheme.
It has to be, I believe,
I think, Member Sinclair, the real angst is how public authorities discharge their functions. And so I keep reminding that if we truly soak in that there is no right to hold a firearm, then some of the concerns may be less. But when you look on the scheme, so you make the application, you know what would disqualify you from applying and what would qualify you from being granted the license. We know who is entrusted with the responsibility of assessing the applications and the grant. It provides for an appeal process, and the law says that if you are refused, you are to give reasons. and it's against the reasons that you're asking for a reconsideration of it. Now, you have the authorization granted for a certain period, and then you have an annual reassessment of the firearm for you to be issued a registration certificate. When the firearm is turned in annually, the holder also is, I guess, assessed again to see if you remain fit and proper for the certificate to be issued. I think the clause will need to be rephrased.
No, I think, yeah.
Yes, would have to be rephrased so that there is clarity around that. Because properly speaking, it is not the holder that is being assessed at the time when the firearm is turned around within 30 days of the birthday. You're testing the firearm, probably just a money-making thing.
I think...
Right? Oh, sorry.
Minister, I think... Shouldn't be. But let's not conflate the issue. If the duty remains that the person should be fit and proper for the entire currency, then that has to be clearly stated. But it's not, while I understand and appreciate your concern, Member Sinclair, the concept of being fit and proper is set out in the Act. It just has to be referenced so we know what you're linking it to. But it is set out. Minister, I think I'll go back to your first comment about the performance of the public offices and how they relate to their clients. There are clearly issues that would not be put on the front burner, so to speak. After you have gone through all the other things in Clause 58, you get the fit and proper. But I don't think there'll be any harm in writing to someone and say, look, based on the intelligence report, if they want the details of the report, then they apply for it through the review panel or through a court order. There might be intelligence report the authority would not be required to give, but if you put that in a letter, then the individual should be aware that, hey, even though something that nobody didn't know except the intelligent people, so him keep quiet. If he is of the view that this is impugning his character without good cause, then he goes to the review panel or to court and get the information. Because the information would have to be credible intel report, which is not always or should not be used should not be given in public form by the authority, or the authority that is obligated not to give, because it may in fact impair the intel sources. But if you go to the individual, but something should be indicated as to why they're not fit and proper. I think that's really, Senator, am I right, Senator? That's your burden, that there should be indication.
Yes,
so
sir.
if you go beyond what is outlined in 58, say there is a broad issue of not fit and proper arising. If it's an intelligence report, let him know. He doesn't have to get the detail of the report. He can then apply to get that in confidence as an individual, or his lawyer be provided the report through the review panel or through a court order.
And I just want to also make a distinction in the two scenarios. In 73, it is where the person has already been issued a license. Right. And so the person now owns property, which is a firearm, which a person, certain constitutional situations will arise in relation to ownership of property. Can't just be in a willy-nilly you go and you hear, well.
Mr. Chairman, as it relates to the property, I just want to address that matter of the property. The firearm remains the property of the holder at all times, even after revocation. It still remains the property of the holder, and the procedure is in the Firearms Act for the person to sell his property if he so wishes.
Minister, just to point out as well, in relation to the concern...
It's not a nonsensical argument. The property is not confiscated, but you're not allowed to use it because the use is subject to certain conditions and authorization. So it may seem a little comical, but if you take it and examine it, but still, I mean, it's still not proper for you to just not indicate why because it's not a revocation of the authorization, and for as long as the authorization remains in force, there is an expectation that the holder would be entitled to use the firearm to which the authorization relates. So this business of just holding on without saying has to stop. I don't know what is happening, because once you have proper information, sufficient information to say that the fitness of the person to hold the firearm is in question, it is to be communicated. It is not right for the authority to say nothing at all while an authorization remains valid. Can't be
And Minister,
appropriate.
I will state on the record here that that is not taking place. I will say to you without doubt that we have statements signed by the individual that can corroborate the fact that they were given a reason at all times. And that is why even when it goes to the review board and the court, they have maintained and hold in favor of the FLA, because what the court has said, Minister, is while the FLA is not entitled to give the clear reason as how it's set out, the gist of it must be provided. And we have always been able to satisfy the court by providing the person's statement to show that they were questioned on the gist of what the information was. So there's no case that has gone to court that has ruled against the FLA, not even to the Court of Appeal, because we are able to show that the person's statements were collected from the persons.
No, Mr. Darling,
Madam.
I think what I was saying, you know, many of these cases are 2-3 years old. I'm saying you might be overlapping if you are suggesting that at this point in time the FLA under your administration is conveying to the individual their reason. That might be true, but there are a lot of applications which individuals have no reason to go on, and I'm saying that that should be made clear that when they are denied or revocated, some reason should be given if it's even implied that it's beyond normal publication.
I just want...
And critically, overcoming the delays, Mr. Darling, is the crucial issue in dealing with appeals. Appeals are 2 years behind still, and until we get current, we'll always have a dispute over what was said or done. That's the real issue. And you have to assure me that the steps being taken now will get us current by the time this law is in place. Because that's the real problem. People waiting 3 years, 4 years, up to 5 years for a reply to an appeal.
And your successes, Mr. Darling, in recent times is because the persons have jumped the statutory review process and gone to judicial review. And that is why the court has always said, in your most recent success, that is what the court's position was, that you should go through the statutory review process before seeking judicial review. It was clearly stated. It has nothing to do with what you just said.
I still want to.
I had raised the question earlier as to the obligation of the FLA. It is definitely against the background of what CEO Mr. Darling indicated, that in normal circumstances they would have just given the gist of the summary of the reason instead of the specifics. So that's why I raised the question as to whether or no we are embarking upon a new paradigm, a new era where we get specific in relation to revocation under Section 73.
Minister, just to
and
clarify...
I think what we are trying to achieve...
Section 84 is where you have to look at the revocation procedures and give them...
Just to clarify what the member just said, Minister, when I said the gist on sensitive matters, but otherwise you are told exactly what the issue is, but there are sensitive matters that Minister alluded to as it relates to intelligence.
Yes.
Mr. Chairman, last week you had commented that we would have been able to do future sittings virtually or a hybrid, and you have not followed through on that commitment.
No, I've asked, but there's a number of issues keep coming up that members want to discuss in camera, in face-to-face, and I keep having to bend on it, because last week we left and they agreed that where we were in the discussion, they would like to have the face-to-face. So it's more ongoing dialogue. In fact, I won't be able to be here on Thursday, and I'm hoping we can have a, hybrid, because physically we won't be able to be here.
Well, I'm glad at least you are accommodated.
All right.
But
let's see if we can do so.
I will remind you, a week like this week, you are asking those of us who do not work full-time with government to come 4 days of the week, because after our 3 days of JSC sittings, we have a Senate sitting on Friday.
Yes.
And I really think, when I recall
Yeah.
For example, the last time we went through something like this with the BOJ Act, after the Joint Select Committee finished sitting, it still took a year and a half for the bill to come.
Well,
the amended bill to come.
I'm going to show you, Member Bunting, and you have occupied this chair too for some time. I'm not allowed to take a year and a half to come. And your time will not be wasted, will not be just abused like that. It amounts to almost abuse of a privilege.
So
occupy you for 4 days without that. So I'm hoping we can really start some hybrid activity, by the end of this week. And conclude.
And I say that, Mr.
Really
Chairman, as a preface to, since you're making such almost unreasonable demands on the membership, that you'll allow some indulgence if we come a little late at some meetings, etc., as
Understood.
we do.
I certainly will. And I said, if you have to refer to further formal discussions that preceded you, we'll try to be, right? We'll be accommodating.
So I came in a little late on the discussion, but I heard the executive director of the FLA saying that when somebody's firearm is seized, they're given the gist of the reason that it is seized, or I don't know if it's seized as a prelude to revocation of the firearm license. But two things. Going back to the earlier discussion last week that a firearm application would be denied on the basis of, remind me, Minister Malahu.
Of a charge of domestic abuse.
No. Reason to believe.
Yeah.
So, since you could have been denied on a reason to believe, you could your application, you could then similarly have it revoked on a reason to believe basis. And since the minister did say that that reason to believe could be an unsubstantiated report or allegation, then is this not going to be...
I didn't say the reason could be an unsubstantiated.
Well, you did say it wasn't evidence.
No, I said reason is not the same as information. It's at a higher level.
You said it wasn't evidence.
I didn't say it was unsubstantiated.
So we on this Joint Select Committee are going to support the continuation of this practice of the FLA being able to arbitrarily and capriciously revoke persons' firearms without having to meet a standard of evidence on the basis of which they are. And I say this particularly, imagine there are persons who make their living as private security guards, and if they don't have a firearm user's permit or license, they will not be able to operate in that capacity. So you're talking about depriving persons of their income and their families, etc. So I really am very concerned with this vague reason to believe, because if that amount of vagueness applies in the application process, then it would similarly apply in the revocation process. And I don't think that is in the interest of natural justice. And I would specifically also ask, in terms of the Section 73, registration of firearm, it says where the holder doesn't renew their firearm within the 30-day period immediately preceding their birthday, they will have committed an offense. Now, having committed that offense, I imagine that would be the grounds for disqualification for continuing with the firearm license. I would like a response to that.
But I would respond in addition. No, it would not be necessarily grounds. It is an offense, and I think what you're looking at, I will indicate to the officer there can be generally, the schedule outlines the penalties for those offenses. And I've asked the team within maybe spend more time when they come in. This part of it is dealing with the licensed firearm holder. There has to be a review of those penalties, because we went through a lot to separate the illegal firearm, now called prohibited weapons, from the legal. So these should be viewed as breaches. They have to be viewed with given a certain weight, but it's not a matter of a revocation or immediate severe penalty.
No, but
it has to have enough weight to let the bearer of the arm realize they have a heavy responsibility, right? So that can be looked at.
no, but I'm trying to what is the policy intent?
What's there?
What is the policy intent? You
Intent is you have to give them
the
time
person will commit an offense, a criminal offense, if they didn't renew their firearm within that 30-day period. And I am questioning whether that what I would consider perhaps something that could be an oversight, something that, for example, during COVID time, somebody may have just found it difficult. You know, an older person during a lockdown period might have found it difficult to travel within the time. Are we criminalizing that, which I think is really an administrative oversight? Even if you put a penalty for late renewal, do we really want to make a person's criminal for missing that window?
The whole objective of this law is separate, and the minister want to come in. Let me allow the minister to come in. Is that legal?
Let me begin by telling Senator Bunting that I do agree with him that it shouldn't be, that perhaps there should be reconsideration as to whether...
No, but if you agree with me, I may have to reconsider my position. Because that...
You see, I agree where we'll both be right, but I must disagree if my agreeing with you would make it wrong. But on this matter, I think you've put forward a sufficient argument for a relook of it, because this is an obligation of the holder of the authorization to submit the firearm annually for inspection in order for a certificate to be issued. And you're inspecting the firearm to ensure that it has not been modified unlawfully, etc., etc. But the person remains a valid holder of an authorization. And it is not the desire to unduly criminalize persons. And so I have a little, someone looking on the law would really want to probe a little deeper as to whether the annual inspection is more than what it appears to be, and it's more for revenue purposes. I say it could be, that question could be asked. But
just to help you, Minister.
But where it says the holder, if you fail to turn it in for inspection, you commit an offense. Without giving a time frame, you can enforce the obligation by giving an extended time, and since you have to pay a fee, I think is what Senator Bunting was saying, the fee could be increased or doubled during that time. There are other schemes which do that. For example, the licensing of attorneys at law. You have a time frame within which you are to renew your license. If you do not do so within that period, then the fee doubles after a while. But you're not debarred from getting your license. It's just so that you are penalized for not having done it in a timely way. So two things, I think, is to take a look again on how do you treat the holder of the authorization who does not turn it in. And in particular, if when it's turned in, there is no problem with the firearms within a time frame. And the second thing is a provision for fitness.
Before you come in, Senator, the Minister has finished. Before you come in, there are two things in here. One, and I'd ask the policy to take a look at it already, because I said the this law took a while to get here because we had to find a way to separate the illegal firearms from the legal. And now having done that, some of these pieces of the section, literally almost a legacy hangover when the two things were combined. There can be a much different approach to this, a different philosophy in dealing with the licensed firearm holder at this point, once he is licensed. And the policy team will ask him to look at it some more. There are two things. It doesn't debar him from getting his license. What it did is to put him in a position where he has to pay a huge fine. And as I said, he ended up with an arrest warrant, which would be
Mr. Chairman, if I would assist you.
So I'm going to ask.
Just look at the penalties now.
No,
it says on summary conviction before a parish court, a fine not exceeding $3 million or imprisonment for a term not exceeding 3 years.
I'm just saying the entire scheme of penalties for the licensed firearm holder breach of the act have been asked to be reviewed already.
Sorry,
all right?
Mr. Chairman, before we escape from it, I think this requirement is very important, you know, because the authority is then able to ensure, too, that a licensed firearm holder is still in possession of his firearm. It is very important.
The review, I mean, there's no compromise on the man coming to review his license annually and to have it properly checked and he goes to a due diligence. That cannot be compromised.
No, I'm speaking about that he's still in possession of his firearm. Because we have had stories where persons have
that's why we have the condition.
So the penalty that we are discussing, I would be cautious in just wanting to just remove it or to view it as an administrative.
No, and that's not what I intended, Senator Sinclair. My suggestion would be just merely missing that 30-day window should not immediately trigger an offense that subjects that person to imprisonment up to 3 years. I'm saying you could say for a 90-day window, they would just pay a penalty. If they're contacted and still refuse, then at some point you could always escalate it to a criminal offense.
No,
but my concern was that merely missing that 30-day window before the penalty should not automatically make a criminal of that.
The minister's going to emphasize that. The point, Minister, emphasize the point raised by the Senator to be emphasized. You know, the issue is to ensure that the person was carrying the firearm when they should, because the danger of the mischief you're trying to is people renting out the firearm and then someone else use it. I said, if a legal firearm owner, unless we get the ballistic signature to cars to check at the time, a legal firearm owner who got it by virtue of one who slipped through the cracks, rent out his firearm for criminal activity, nobody goes to look for his firearm until you get the ballistic signature. You know? So this is just that mischief. But the points raised, we'll look at it. Minister, you want to clarify it a little bit?
Again, just clarify. This provision places an obligation on the firearm holder to do something. And under the provision, it is to submit the firearm for inspection. That is the duty. If breached, it becomes an offense. The duty to submit.
Within that 30-day window.
So the certificate that is issued after inspection is one that is valid from one birthday to the next. The 30-day allow you an advance time so you do not have to wait until the certificate expires and then you are holding the firearm without it being duly inspected. And then it's a birthday. So remember, when timelines were changed around birthday, it was precisely to deal with the problem that many said, boy, sometimes the expiry date happens upon me and I don't recall. And they say, all right, it's hardly unlikely that people forget their birthdays. So let us mark it with a birthday and give you a time frame. So this issue of the birthday was put in place specifically to deal with the concern raised about timelines that people can genuinely forget, right? And the advance time It's not saying that you must come 30 days. You have a 30-day period within which, so you may forget it to do so within the first day. You might only remember 2 days before your birthday or on your birthday. So it does, but the point as to whether your first port of call in breaching the duty should be an offense is one I agree with, that it can be reconsidered. But it cannot be an extended timeline. It could be within another 30 days post the birthday. So you have 30 days preceding and 30 days following, and then it can kick in afterwards.
There are two members that's coming. I think Member Jackson was up first, and then Senator Scott Motley. Bear in mind, you look at two aspects. The issue of the timeline is of value, and this is why we have stopped third-party registration. All of that is become important. But the other source, go ahead, Mr. Jackson.
Well, first of all, my apologies for being a bit late, but I realized I didn't miss much.
Senator tells me that you're a full-time government employee.
Well, you know, Chairman, this morning in particular, Thursday is a special day. It's PEP exam day. So some of us have some standing duties for our PEP students. So I had to make a choice whether to be late here or to be in order there.
I think another senator says that they didn't know that you are PEP students. One of your colleagues said they didn't know that you had such a young one.
No, I think you're listening too much to Senator Bunting, because he asked me that question. I told him that I had 4 primary school of children. So there's a lot that I do have. But to the matter at hand, Chairman, I hear the debate and I concur with both Minister and Senator Bunting regarding the criminalizing of the not registering, not turning in for inspection in that 30-day period. But I think I have a bigger issue. The license is for 5 years, right? You test the person, establish their competence, they acquire the firearm, it is deemed to be in good order, and what of it is determined. Why is it that they have to inspect every year? Because you're going to have to renew 5 years. It's not like a motor vehicle that I can understand driving every day on the road, or presumed to be driving every day on the road. Why is it that someone have to take in the firearm every 12 months to look on it to see if what? I would want to believe that within the 5-year period, if the authority, as it does, have reasons to believe that that firearm being held by that licensed firearm holder was involved in a criminal activity or even a suspicious activity, it can then ask for the firearm to come in within that 1-year period anyway. So given that authority that the authority has to have it come in, I'm curious, Chairman, why is it that every 12 months the FLA or whichever authority have that responsibility have to see the firearm to inspect it, and there is no basis of anything untoward ever happened by the firearm holder or that firearm use? So if you can help me to better understand it, because for me it's an unnecessary bureaucratic exercise that is being invoked. Solicit, require the firearm if you have reasons to. But if it's a fee thing, again, and Mr. Dallin is here, but I want to remind Mr. Dallin that we look at the law not on the basis of who the incumbent is, right? It's for whoever, what the institution does. If it's a fee thing, we understand, right? And as Minister said, if you breach the 1-year payment,
give them the option to pay the 5-year fee one time.
Give the option to pay the 5-year fee. And I don't know if it's because you want to leave room to be able to increase it on an annual basis.
Member Jackson.
But you can even make it probably retroactive for within that 5-year period if you wish.
Member Jackson, the point raised and explained and the minister concurred that there's some, having taken steps to separate, as I said, illegal and go back, which is what allows it to be a bit more liberal with the license holder. But the annual inspection has to be part of it. In fact, it should be more than annual, because yes, if you're talking about.
But why? No, I am
because,
open to be convinced. Why?
I mean, what I'm looking at, I said, is, and I want I'll take Senator Scott Mattis' comment to you, but I just saying it. The annual review is important. The 5 years a review of the fitness of the product, not in terms of the ethical issues raised here, but a person carrying a firearm, which is a dangerous weapon, you make sure he's still physically and mentally and otherwise fit to do it. That's renewal. But the annual note to know that you have this weapon. You see, it's members ask. We go back to the. Yeah, sure. I take Senator.
I was thinking that since you were going to be relooking the offenses for the failure to do it on time, that perhaps what could also be considered is a whole question of reasonable excuse. And I make this suggestion because with COVID, for example, or if somebody has surgery, hospitalized and have surgery, they could easily miss a date, and they would be required, they could simply produce proof and get consideration.
Let me thank you for your interjection. Always Senator Scott Mattis brings a level of good reasoning, the right thing. But no, on a serious note, those are, I think, should be considered, and I know your colleagues have suggested across the floor. I would agree with you on that issue. But the inspection is critical to, one, to not only verify the holder keeps the firearm and is aware of his firearm, is in possession of it at all times, where there's a reasonable excuse if he's late or so, those are valid issues. But beyond that, part of the replacement of the Firearms Act for the, what is now the Firearms Prohibition, Restriction and Regulation Act, is to maintain a message, and why we look for review on it. The firearm in Jamaica is a killing machine, pistols and rifles in particular, right? And that message has to be part of the legitimate part of the legislation. You have two schedules, I said, two sections, and that must be one. Anybody who carries a firearm is carrying a weapon, an instrument of death, and therefore their sense of responsibility must never be relieved. I said in one case, a man who denied it to me, and I think is a better way to look at it. He said, Dr. Chan, I don't want a license because having a gun is like a baby, a young baby. I'm responsible every 24/7 I have to take account of it. And therefore, to that extent, the annual inspection and review is important. It's not a burden, and I agree in terms of penalties for not meeting that 30 day need to be looked at. I think we all agree on that. That we would not want to criminalize a man for that, but he have to keep in his mind that having a firearm, a pistol or a rifle, which is rare in the mix of pistol, is a weapon of death that must be kept secure and that is safe, and he knows where it is, he knows it's a safe place, he has a responsibility to manage that weapon at a certain level of seriousness. Much different from a car.
Chairman, don't worry going any further. I am sufficiently convinced.
Right. Thank you, sir. Right?
Chairman?
No, Mr. Chairman, I'm not convinced. I would like you to present the data. My knowledge of the problem we have is overwhelmingly with illegal firearms. But this is treating the licensed firearm holders almost as aggressively. And I would like to see the data that informs the policy. What are the breaches we have seen? What are the charges, the convictions of persons who have license? Have they abused those licenses? How many of them have abused it? Let's look back at 10 years, for the last 10 years, and see. I mean, that should inform our decision making. It should be evidence-based, not based on emotion.
That's not data that inform the base, Mr. It doesn't make sense to seek to bring it to you.
Sorry?
That is not the relevant data.
How do you mean it's not relevant?
A firearm, 90% of the people killed is killed with a 9mm or 45, which is a popular gun that people carry.
And I would challenge you that 99% of those are illegal firearms, not carried by licensed firearm holders.
Chairman, maybe I could offer what I'm suggesting, maybe a middle view. I think I am very clear and share your view that
the responsibility of holding a firearm is an extremely serious responsibility and not one that should be granted with any sense that the firearm holder gets a license and then, there's no interaction between themselves and the FLA until the license expires. Might I offer to the committee for consideration a scheme in relation to the inspection system that would offer monetary penalties that would be ongoing for as long as the firearm holder did not bring that weapon in for inspection. For two reasons. Because it continues to climb, it places a burden on the firearm holder to ensure that they move quickly to get their firearm inspected. It doesn't criminalize the firearm holder, doesn't impugn an offense that they would be brought before the court for some criminal penalty. And also, it ensures that whole sense of responsibility and urgency to comply for your consideration.
I think that's really where we're heading, Senator. You came a bit later. We agreed that we'd have to look at how we hold them accountable, the process that currently, as proposed, is a bit sharp. I indicate it's coming from the old law technically, where there was a kind of overlap, but the sense of responsibility to retain. So that is how you do it. I think we have agreed.
What I'm really emphasizing, though, Chair, is not just a monetary penalty, but a monetary penalty that continues to accrue.
So, Mr. Chairman, am I to understand that you're saying to this committee that you're not presenting any data on the offenses or abuses carried out by licensed firearm holders over a period of time to inform the deliberations of the committee?
The primary data that drives the structure of this law is one that is irrefutable. What we have is that 9mm, some 38 and 45 kill 1,200 people annually in Jamaica.
And I'm saying, I want to know, of those 1,200 persons killed, how many were killed by a licensed firearm or a licensed firearm holder?
That's what it is. That's right. That's
but
the gun that's killing.
If the scheme makes a distinction between illegal guns and licensed guns, then why would we not look at the distinction in the data? Why would you want to deprive us of that data? I assume that that data is available.
Chairman, through you, the data suggests that the greater harm is done in relation to firearms that are illicitly trafficked and possessed outside of the lawful firearms trade and those which are registered. And that data informed the dual scheme of the Act. All right? It is also the policy that those who go through the deeper vetting and are issued with an appropriate form of authorization would be treated differently. At the same time, those who are entrusted with an authorization to possess and use a firearm are still regulated in a somewhat onerous way because the firearm is a lethal weapon. So duties and obligations are placed which must be satisfied, and they have consequences. So to kind of ask and suggest that the minister is not bringing the data strikes me as a little mischievous, because it was a starting point that the data revealed the greater harm being done on the one side where we have the prohibition as opposed to the restriction and regulation. And in respect of this clause, the point is taken, and I believe the committees would, from the discussion, accept that notwithstanding the use of the birthday, which is aimed at helping someone to better remember a timeline, then consideration should be given to not immediately criminalizing the holder of an authorization who fails to discharge the obligation to submit the firearm for inspection. Right. And there are more than one suggestion on the floor. One relates to providing a grace period of 30 days after. And we have provisions that can be used where no prosecution would take place within those 30 days post. And then the other suggestion is to provide for reasonable excuse for failing to discharge the obligation. And both are being put forward. But the duty initially is regarded as a strict duty. So the first reprieve of giving you a grace period afterwards is one that would fit into the scheme. Because even though you are authorized, modifications can be done to a firearm which makes it difficult to trace it. So the
and you're arguing a point that we've moved on from. That's not the point I'm making. I'm making a point is why is this Parliament, through this committee, being treated with such contempt by the executive?
Come on,
by suggesting
Senator
that you have the data, but you will
really
not share it with this committee to allow us to form our own opinions and make up our own minds around all the issues, not just to do with this clause, but all the issues that are being contemplated in this firearms prohibition, restriction, and regulation.
You know, it's really unfortunate that you use this clause to make that point, and I'm sure that point is directed at a different audience from here, because it is plainly not true to say that the executive is being abusive and is not bringing the information to the committee. The minister who chairs the committee directed the technical team from his ministry to do a summation of the data that informed the cabinet submission to bring to the committee. Perhaps you were not present at the time, or your attention was directed in another direction. But please don't be mischievous in that. There is no intention on the part of the executive to hide any data. This is an issue that affects all of Jamaica, regardless of which party forms government.
Look, stop
you were in the
speechifying.
post at one time.
If the data is there, just present it.
You're asking for a data in respect of this clause. I don't know that the minister has it disaggregated in the way that you're doing it, but I indicated to you through the minister that the data revealed a greater harm on the side where the firearms are illicitly trafficked.
My own opinion. I would like to see the data.
Minister, but
I think I'm entitled to form my own opinion and not rely on your interpretation of the data.
I think Minister spoke quite clearly on the issue, because I don't need to be for clarification. I said the clauses 52, if I recall, 56 through to almost 85 with the authorization and largely on suspension of authorization, is where the issue deals with the regulation of the licensed firearm holder, because and if there are areas there where you might think the sentence may be a bit over-aggressive, we think we'll look at it. We have agreed to that issue. The firearm in this society, I don't need any more data, Senator, not a matter of treating you with any disrespect for the House. Everybody in the House is aware of 3,000 plus shooting taking place in Jamaica from time to time, and at least 1,200 ending up in death. That is the data, and I don't think we need to look at any more data to decide how we treat a firearm. And anybody who is carrying it, whether licensed or unlicensed, he goes through a process to get the license. He carries a weapon that is lethal and must bear in mind that he has a serious responsibility.
Chair, tell me if I'm wrong. My recollection was that you committed to bring in the data to the committee, but we would go through this process of going through the provisions, and then we would have the sessions with the data and the submissions. Isn't that my understanding?
Sure the data we discussed at the time, did not break out in this format you're referring to, and I don't
No,
think
I assumed you meant the data informing the policy generally, so that whatever provisions would trouble anyone, they would be able to look at what you brought and determine that, okay, this answers this question, this answers the other. That was what I got from what you had said.
That's what the minister said.
Yes, so we just have to get through this process, which is a little tedious, but it is necessary. And then we will have those sessions. I don't think Senator Bunting was present at that particular committee meeting.
A number of that data was brought in the presentation from the FLA itself. I think bulk of the data was brought. I'm not sure who was at the time. Yes, sir.
Chairman, I believe the recommendations accepted have been summarized, which the report would carry. And we would go to...
Chairman, just a comment on your interpretation of the statistics. And I might sound like a recurring decimal. I said it before, and I'll keep repeating myself. I understand that guns may be the weapon of choice in this country, but I said it before that guns do not kill people. People kill people. And I'll keep repeating it. No. So just to continue to state that guns are doing this and that is not enough. But I understand what we are here to do. But understand that my position is that guns are not necessarily what kills people. It is people that kill people.
Clarification. People use guns to kill people. People don't kill people like that. People kill people. They chop them up and them hang them. We know. But that's 20% of what happened, 25% of is what. People use guns to kill people in Jamaica. That's what they do, and that's why the emphasis on the firearm license.
Madam CPC, please proceed.
74, duty to safely store firearm and ammunition. 1, the holder of a firearm authorization shall ensure that each firearm and all ammunition in respect of which the authorization applies is safely stored in accordance with such standards as shall be prescribed, so that no other person can gain access to the firearm or ammunition, as the case may be. 2, a person who contravenes subsection 1 commits an offense. 3, for the avoidance of doubt, if the loss or theft of a firearm or ammunition is attributable to the negligence of the holder of a firearm authorization in respect of the firearm or ammunition, as the case may be, the holder contravenes subsection 1. 75, special restrictions upon holder of firearm manufacturers, firearm broker's license, or firearm dealer's license. 1, the holder of a firearm manufacturer's license, firearm broker's license, or a firearm dealer's license shall not manufacture or deal in firearms or ammunition at a place other than at the place specified in the license. 2, a person who contravenes subsection 1 commits an offense. 76, records to be maintained by a relevant licensee. 1, every relevant licensee, as defined in this section, shall, in accordance with this section, establish and maintain a record of all transactions relating to that licensee's business as a licensee. 2, record referred to in subsection 1 shall be in such form and shall contain such particulars as may be prescribed by the minister after consultation with the authority. 3, the particulars required to be recorded under subsection 1 in respect of a transaction shall be made within 24 hours after the transaction takes place, and in the case of a transaction involving a sale or transfer, the relevant licensee shall, A, at the time of the transaction, require the purchaser or transferee, as the case may be, to furnish particulars sufficient for identification, and B, immediately enter those particulars into the record. 4, where a person ceases to operate as a relevant licensee, the person shall forward all records maintained under this section to the authority no later than 30 days after the cessation. 5, a relevant licensee shall, A, on being requested to do so by a person who is 1, a constable duly authorized in writing by the divisional commander, 2, An officer of the authority duly authorized in writing by the Chief Executive Officer of the authority. 3, a customs officer duly authorized in writing by the Commissioner of Customs. Or 4, so authorized by the Minister, allow that person to enter and inspect the record of transactions required to be kept under subsection 1 and the relevant licensee's inventory of firearms and ammunition. And B, on being requested to do so by any person who is 1, a member of the constabulary force above the rank of inspector, or any constable duly authorized in writing by the divisional commander. 2, an authorized representative of the authority. 3, a customs officer duly authorized in writing by the Commissioner of Customs. Or 4, so authorized in writing by the Minister, produce to that person for inspection the record required to be maintained under subsection 1.
CPC, if I might interrupt you, through you, Chair. In paragraph 4 of subclause 5, where we have a person so authorized by the Minister, is there any particular credential that that person must carry? Are we talking about a administrative person in the ministry? Who gets to be so authorized by the Minister?
No, the FLA inspector. But we do have a department in the ministry that is clearly identified that can carry out inspection. But this will be the FLA authoring, Mr. Darling.
Is there any more specific language we can put to that? I guess a little concerned about the potential for abuse with a person without defining who that person is or what body that person ought to sit in.
It's also the FLA, the short SSICIB. Mr. Richard, you want to define them that do inspectorate. There's an inspectorate branch in the ministry that helps by that does inspection of this sort, business places, etc.
I mean, as this is written, I could be authorized by the Minister, couldn't I?
But I don't know if it's written that way. I can't authorize it in the body. They either have the FLA or the SSI-CIB in the Ministry of National Security. And that's
correct, Minister.
That's legal. If I went beyond that framework, I'd be...
Minister, I'm not understanding. Can you say that again?
So remember, in terms of so authorized by the Minister, quite typically what would happen in this specific case, the Minister would authorize the specific branch or the individuals in the branch in the ministry that would be engaged in these functions.
I know that it happens quite typically. My concern is the law at the moment does not mandate that those be the only persons so authorized. And so my concern is in some realm where we go through a situation where there's a minister who is particularly abusive of the provision, can language be put in there to specify or in some sort of way narrow where that person so authorized ought to come from?
Point taken, member, and we'll do that.
Chairman, I support that observation by Senator Campbell.
It's just to ensure that it falls within what is intended.
Yeah, well,
because we're left open.
But so I'm not. I'm be advising the law because as it stands now, I know I said can only authorize someone from the SICB and the FLA to do inspection of any.
It's a good point you made.
So I have no. Just want to know that if it need to be indicated clearly in the law that these are the people I'm allowed to authorize.
Mr. Chairman, quickly, is there any reason why in 5A Roman numeral 4 in writing is left out, but it is so in...
Sorry, we saw that as well, Member Sinclair, and
okay.
we'll address that as well.
All right, thanks.
Six.
I'm not. why the inspector to the ministry was not mentioned, because that would really just, rather than saying anyone, well, we have this committee, anyone authorized and right by the minister, but it has to be somebody from a particular department. And in addition to those laid out, the only other department I am aware of would be what is alluded to by Mr. Bailey, the inspector
The
of the ministry.
the other thing is that we may just have to reconcile the definition of authorized officer, which falls in the interpretation clause 2, because among the persons enumerated there is a person designated in writing as an authorized officer for the purposes of this act by the minister. So when we're looking at it, just let's do a little reconciliation.
Well, the structure of the law, you'll have to tell me how, but I said maybe one of the things is I said there's just one more department that can be added to what's listed here, is the inspectorate branch of the Mr. Nasigo. The people are trained, designated, and are available to inspect, especially the business places that store firearms, and they have to verify that it is of adequate security.
Minister,
All right, you can move on.
would that also apply to B4? Senator Golden referred to A4, but
the general wording of authorized in writing by the minister would apply to all sections here.
So, okay.
To make sure that the minister can just write and give.
Right.
The member from
I
Portmore
fully
right to
support
go
that.
inspect his.
And just a little suggestion: the layout for B, that's how it is formatted, because it's separate B rather
Yes,
than
it's
have it flowing.
misaligned in the print.
That's just a formatting.
6, a person required to be authorized in writing to make a request under subsection 5A or B shall show the written authorization if requested to do so by the relevant licensee. 7, a relevant licensee shall make such returns to the authority in such form, in respect of such periods, at such time, and containing such particulars as may be prescribed. 8, a relevant licensee who contravenes this section or knowingly makes any false entry in a record required to be maintained under subsection 1 commits an offense. 9, records maintained by a relevant licensee.
It's to be taken.
Yes, it's a typo. 9, records maintained by a relevant licensee for the purposes of this section shall be retained by the relevant licensee for a period of not less than 20 years. 10, in this section and section 77, relevant licensee means the holder of a firearm manufacturer's license, firearm dealer's license, firearm broker's license, gun club license, gunsmith's license, or a firearm range operator's license. 77, relevant licensee to display notice. 1, every relevant licensee shall display prominently and properly affixed to the structure of the premises in respect of which a license is granted in such manner as is prescribed by the authority, the name in full of the relevant licensee, followed by the words licensed as a firearm manufacturer, licensed as a firearm dealer, licensed as a gunsmith, licensed as a firearm broker, licensed as a gun club, or licensed as a firearm range operator, as the case may be. 2, a relevant licensee who contravenes this section commits an offense.
Just to be clear, that in such manner as may be prescribed relates to how the license is properly affixed and not to the license itself. So just see. Shall display prominently and properly affixed to the structure of the premises in respect of which the license is granted in such manner as is prescribed. That's in the right place. That rider is in the right place. All right. Okay.
So just a question. I don't know that I saw it in my read of the bill, but there's no restriction on how records are kept and maintained, in what format? Is there? I know our old bills would have restrictions, or old acts rather would have restrictions. I just wanted to be sure.
Well, the Electronic Transactions Act would apply so that anything that can be done in writing can also be done in electronic form. Right. 79, temporary storage or custody of firearms or ammunition. 1. A holder of a firearm user's license who desires to make an arrangement for the temporary storage or custody of a firearm or ammunition to which the license relates may arrange for the storage of the firearm or ammunition at such place and under such conditions as may be approved by the authority in consultation with the divisional commander, or deliver such firearm or ammunition either to A, an authorized person at the authority, or B, the sub-officer in charge of any police station specified in the 4th schedule for storage at a facility listed in the 4th schedule. 2, the holder of a firearm user's license shall not make or permit any arrangement for the storage or custody of any firearm or ammunition to which the license relates in circumstances where the arrangement results in that firearm or ammunition being out of the holder's possession, if that arrangement is not in accordance with subsection 1.
Mr. Chairman, this section is not clear to me. Let us say, for example, a firearm, the holder of a firearm user's license is a member of Parliament. The Parliament prohibits you bringing a weapon to a sitting. They leave it at their home in the safe that was inspected by the FLA before they were issued a license. Now, the firearm and ammunition will be out of their possession. So is it now that leaving it in their safe, they would be committing an offense? This seems to be written so broadly that every time it is leaving your possession, you would have to surrender it to either the sub-officer of a police station or authorized person at the authority. This cannot be the intention.
May I, Chair? Because isn't possession defined in law as being within the person's control? So if it's in your safe, locked away, it's still under your control and therefore still in your possession.
If that's the definition, then I thank you for the clarification. But in the existing Firearms Act, I think, for example, and I just ask that it be clarified if that has been removed. There used to be or there is a condition that if you travel overseas.
Yeah,
and now, I can understand in the days when you used to take a steamer to England and you're going to be away for an extended period. But people now travel overseas in the morning and return in the afternoon. Has that requirement been removed updated in this bill? Or is there such a specific provision that still exists?
I would cover that, but I'm open to advice on the legal structure. But Member Jackson.
Yes, Chairman. My concern relates to Senator Bunting's point that another persons have raised it with me. Essentially, a firearm holder who is required as a condition of being granted a user's permit or license to have a safe in their dwelling place for safekeeping. If the person locks it in the safe and goes to the supermarket, it's not a breach, I presume.
My understanding is, as was explained by Senator Golding Campbell, is that it is still under his control and possession.
Yeah, I heard that, but so, I use the supermarket to extend it a bit further.
Pretty
much like what Senator Bunting mentioned of. If the safe is there for safekeeping, is there a minimum time permissible that they can be not in the physical presence? Because if you travel to Montego Bay from Kingston, go on for the whole day, like traveling to Miami.
Look, that's not my understanding, and that's not the intention. I said the structure of the clause, as far as I'm concerned, but there's no intention to criminalize someone for leaving their farm and they're safe. They come to Parliament are going to for 4 or 5 days.
No,
so.
that's the nebulous part about it, Chairman.
Yeah.
The duration. I understand and appreciate the point you are making. Because how long is away from it to be in the safekeeping? As an example. No. If the person lives in Kingston and goes to Montego Bay for the day, or 2 days, or the weekend, left it in the safe, does that constitute a breach? That's the point I make when I said it was nebulous. What is the duration that...
All right, look at it this way, Member Jackson. So what the law is providing for is, so the law says that you are required to have proper storage for the firearm and ammunition. Possession in law is defined as knowledge, custody, and control. All right? You know where it is, it's under your control, you have custody of it, but it's not on your person. All right? If you wish to make arrangements that will divest you of possession of the firearm, temporarily so, the law provides, it gives you an avenue to do so. So if we skip over to the 4th schedule, it tells you where at the police stations you can do so.
No, before you go to the police station, my point is simply now, colleagues.
So the other, just hold on, clause 2, 79.2 says, the holder of the license shall not make or permit any arrangement for storage or custody of a firearm or ammunition to which the license relate in circumstances where the arrangement results in that firearm or ammunition being out of the holder's possession if the arrangement is not in accordance with subsection 1.
But Minister, over a second there. I fully follow that which you said. I'm speaking to a literal case. Senator Bunting's example is one such. Miami used Florida as an example. I use Montego Bay for the weekend. It's in the firearm holder's safe. He's not physically around it. Just the same as if he's not physically around it if he left it in the safe to go to the supermarket. All I'm simply trying to clarify in my own mind is in those circumstances where he knows where it is in a secured place that is deemed secured by the FLA, which was a condition of the license being granted in the first instance. The fact that he's away from it in that safe for 1 day, 2 days, 3 days, a week, does section 79.3 applies?
Look at it in conjunction with 74. At 74, in respect of obligation, the holder of the firearm authorization shall ensure that the firearm and all ammunition in respect of which the authorization applies is safely stored in accordance with the standards as shall be prescribed so that no other person can gain access to the firearm or ammunition as the case may be. And for the avoidance of doubt, if the loss or theft of a firearm or ammunition is attributable to the negligence, to the negligence of the holder, right? No. Then you contravene the provision.
Okay, so let me put it in simple layman's term. Simple layman's non-legal term. If you left it in there for a week and nothing occurred, no breach would have occurred. That correct? Yes. No, but in the first instance, if John Brown left it in the safe and is away from in the other part of the country or in another country for a week and nothing happens, no section 79.3 does not
Again, you know, matters of law are determined in accordance with principles of law. So for negligence, you have to have a defined duty, you have to have a breach, and then you have to have damage, a loss that
with
results.
all due respect, don't complicate my simple question.
No, it's not complication.
No, my
it's what
simple
the law
question is that John Brown
So
have a
hold
firearm.
on, no, Member Jackson. So if you're going away for an extended period and you're not bringing the key, right, and something may happen, every case is going to be assessed on its own circumstance. It tells you, hold on, it tells you very clearly the duty that is placed on you. It tells you what and under what circumstance that duty would be regarded as being breached. It also provides you with an avenue to divest yourself of possession of it. And it says that if you arrange for yourself to be divested, contrary to what is provided in the law, you commit an offense.
No.
Chairman.
Right.
Chairman. I see another lawyer on TV.
No, Chairman, I'm not.
He doesn't complicate it further.
Chairman, I am not approaching it from the point of view of a lawyer now. Right? I am approaching the thing from the point of view of a holder who travels overseas. Now, the reality, Chairman, is that the challenge faced by many firearm holders now is that when they travel overseas, they expose themselves by going to a police station ever so often to leave their firearms there or to leave it in the custody of the FLA. I don't have a problem with the custody of the FLA. However, if you look at how the law is structured now, I am at Parliament. It's in a safe. I don't know how long I'll be here for, right?
Not a little later.
Therefore, in simple terms, Chairman, hold on. So, Chairman, the point that we're trying to get at is this. In the event that somebody travels overseas, leaves the firearm in a safe for, say, a week, does that contravene Section 79 of
Chairman.
This Act? And it needs to be clear because we're on the record here now. So it needs to be clear.
Chairman, though, but as layman, my understanding is from what the minister said. If I leave the firearm at home where I still have family and it's the safe approved and the keys are there and nobody has been, it's still under my control, my possession and safely.
Chairman,
that can be a fair length of time if they go away without and give it to somebody else or leave it in somebody else safe, and that's a different thing, or they go for 6 months or a year to work. But if it's in my home, in the safe approved by the FLA, and my family who's still there, I'm in control and in possession adequately. So whether a week or a month is not,
Chairman, I think the difficulty for the lay person is a confusion of being physically away from the weapon and possession and possessing the weapon. Now, in law, you can possess the weapon and be physically away from it so long as you have secured it in your safe, which has been inspected, and nobody else has access to it. And, there's no negligence on your part, meaning you have not done something to cause it to be taken from the safe, or you have not omitted doing something to ensure its protection in the safe. So that if I put my firearm in the safe and a terrorist comes and bombs my house and the safe blow up and he gets the firearm, I haven't been negligent because I did everything I could do to protect the firearm in the safe. But if I close the safe and for some reason I've left the combination on the table beside it, then that is negligent. Or leave the key. I'm sure. Remember, Jackson, that worse things have been done as you move on to senior years. So
you step out of your vehicle and leave the firearm on the seat of it, knowing that people are around.
Jackson, I think we have some adequate defense laws here would ensure that we do that breach.
But Chairman, I think that we need to step back from this discussion a little bit to look at how the section is actually worded. And it does not place an obligation on the person once they are separated from their firearm to surrender it in these circumstances. It says that if you desire to make an arrangement for the temporary storage or custody of the firearm or the ammunition. And so in the circumstances where somebody is in Montego Bay for a weekend, staying at which hotel would you stay at, Minister? The whole point of it is that that is not determined as parting with possession. So I think that we have to look at the section in the context of, as Senator Golden Campbell said, what does possession constitute? And remember that you don't have to do it. Of course, there are consequences if something happens and you have not actually separated yourself from being in possession. But I think we are kind of overthinking this particular section.
I could ask, is possession defined in the interpretation section, Minister? It's defined in common law. All right, we know what it is. All right, Senator has a summary contribution. Member Cousins, you still want to come in after Senator?
No, I was just pointing out that there is a section 45(2) in the existing Firearms Act that I was really referring to, which puts a special obligation on firearm licensees to, if they're traveling overseas, to surrender the weapon, even though by this definition it would still be under their possession. But Mr. Rowan Richards who I consulted with informally, has advised that special carve-out has been removed and is now captured under the general clause, which I think makes a lot more sense, because that one was sort of old-fashioned and, led back to a time when people rarely traveled, or if they did travel, they traveled for extended periods, like by steamboat.
Minister.
Yeah, Chairman.
Just to add to that the law, we should always be clear as to what duty is placed on the holder. The duty is to safely store the firearm and to ensure that no one has access to it. Because so you may or may not desire to make a certain kind of arrangement that divest yourself of possession of it. But if you're doing so, the law sets out how it is to be done. Because outside of that, you really don't have an option. But it is not saying that you have to do it, but where circumstances require you to do so without actually saying so, if you desire to do so.
And I'm now
Chairman.
clear, and I agree with this, this new provision.
I am in agreement with the new provisions. However, Chairman, let me just say this, that there's a common practice in Jamaica, you see. When a licensed firearm holder is leaving, sometimes they leave their firearm in the possession of another firearm holder who has the similar caliber weapon. It happens. Let us be realistic. So let us just face the issues head on. Now, based on this provision, it happens. Clause 81 is there? It's still here? All right,
so we know that a number of things happen, and you're right to bring attention to it, but the intention is to do a reset with this law, to say to persons that all the irregular practices, so it may be linking it back to the request for data, because one case of fatality may be one case too much, right? So we're clearly defining the duties, we're giving you options, we're telling you what you can and cannot do in the circumstances when you are issued an authorization to hold and use a firearm. And outside of that, you have to face the music.
Chairman, I'm mindful of the fact that this sitting is public, is being viewed by the public. So it's important that whilst we are going through this process, that we are clear on certain issues, because the members of the public are in fact looking on. And so that is why I raised the point. And another point I wanted to raise was, I noticed the silence of the FLA right at this point of the conversation. I was wondering if the FLA has any views on it, on this particular subject, because at the end of the day, there's the impression out there is that there's an obligation on the firearm holder to leave his firearm at the FLA. And the way sometimes the thing is worded, it seems to give that impression. So I'm saying we're doing this for the public is watching, and so if we can contribute in any way to educate the public on the issues, we just have to educate them. It's very important, Chairman.
The point is taken, Member, and we're going to indicate as we conclude that when we look back at the role of the FLA even if not in the statute, when the regulation, one of the things I'm going to ask FLA to do, we can't do the public education in this session, although the contribution would be of value. But the FLA, as part of their statutory responsibility, should do more public education on the responsibility, carrying a firearm, and all the conditions surrounding its storage, its use, etc., because that is something we'll have to come with the new Firearms Act. Clearly, having separated the two things, the illegal from the legal firearm holder must be fully briefed on how to handle his firearm, because the gun is still a lethal weapon. And the firearm authority will have to carry that responsibility much more aggressively.
Not to cut you, but if, for example, we're here in Parliament, it would be permissible for us to leave our firearm with the close protection officer whilst we're
Well, as a police officer, he's an authorized officer, separate from your friend. All right?
Chairman, it may be useful for us to just jump over to the 4th schedule to just advise
But
of the
before
list of
Minister
facilities
before
for
the Minister
temporary
move
storage.
on, I thought my colleague had asked for the silence to be broken by the FLA.
No,
Moving right along.
Time.
Moving right along. Right, fourth schedule is on page 93. The list of facilities for temporary storage or custody of firearms
Actually, remember,
and
Minister, that
ammunition.
his center call indicate that some of these sections do apply to people like my friend himself and myself. They were of an earlier vintage. That's what Go ahead.
Fourth schedule.
Fourth schedule, list of facilities for temporary storage or custody of firearms or ammunition. 1, any of the following police stations. 1, Kingston Central, East Queen Street. 2, Kingston Eastern, Elletson Road. 3, Kingston Western, Denham Town. 4, St. Andrew North, Constant Spring. 5, St. Andrew Central, Halfway Tree. 6, St. Andrew South, Hunts Bay. 7, Morants Bay. 8, Port Antonio. 9, Port Maria. 10, St. Anne's Bay. 11, Falmouth. 12, Montego Bay, Freeport. 13, Lucy. 14, Savannah Lamar. 15, Black River. 16, Mandeville. 17, Maypen. 18, Spanish Town. 19, Norman Manley Airport, International Airport. 20, Sangster International Airport. 21, National Stadium. 2, any of the following offices of the Firearm Licensing Authority. A, Head Office Kingston. B, Regional Office Mandeville, Manchester. C, Regional Office Montego Bay, St. James. D, Regional Office St. Anne. And any other office of the Firearm Licensing Authority as may be designated by the Minister for the purpose of this paragraph by notice published in the Gazette.
That a large area like Portmore is not included in this area. With so many residents, and at the same time we're spouting about parish and all that. Nowhere, Mr. Chairman, I read the section 3 times searching for Portmore. And you have a divisional headquarters there already without being a parish, of course. Spanish, I don't want to go that far yet. I don't leave Portmore yet. I don't leave Portmore yet, but I'm not getting nothing here. I'm not getting nothing here.
So we need to revise that section.
But I know that was an oversight. I won't accuse anybody of any ill intent. I just see it as a genuine oversight.
Remember, we hear you loud and clear, and I know that it all depends on this armory at the particular station, so if it could have been an oversight. Remember, and we provide enough land for you to have a full-fledged station and other things at the town centre of Portmore. And since I had some responsibility to remind you, I did take adequate precautions to provide adequate land space.
Well, I think there's enough room space at the St. Catherine South Division.
I expect it has to do with the armory at the station. If it wasn't done, I suspect it will be required. But
by the time this exercise is completed,
we could check.
That could be put in place. No, but seriously, there's a large number of residents in Portmore.
Well, I said it's not the number; it would be the quality of the armory at the station.
Yeah.
That was built. If it was built,
have a look at that.
Sorry, Chair.
Mr. Chairman, with regard to this storage, is there a prescribed form of receipt that the license holder would get from whether the police station or any other storage facility?
Yeah, prescribed
There
form.
is a current form that is used. I'm not saying it is prescribed. Maybe it should be prescribed. To be
used by
uniform
the
across.
FLA, or is there one form used right across the system, all the police stations, etc.?
Right, that's what I was saying, that there's a consistent form used by the FLA, but as it's being done now, going across the police, I think we should have a prescribed one, that it's uniform.
Or at least state what should be on the receipt at a minimum. Because otherwise you'll get inconsistencies and every who is surrendered to might come up with his own form.
I mean, it would stand to reason that the holder, the license, the place, and the person who actually, details in respect of the firearm and details in respect of the place.
The firearm license holder.
The license, the firearm itself, and the person who received it.
Right. So I'm saying, should we prescribe that?
Yes.
Yeah.
Yes. So that you don't have
accepted
disparity.
Okay.
To be added to this.
Thank you.
Schedule.
Sorry, Chairman, if I may. Thanks. I'd ask the committee to look on page 79, clause 106. Clause 79, no, page 79, clause 106. It says the minister may from time to time by order, subject to affirmative resolution, amend the first, second, third, or fifth schedule. Does not include the fourth schedule. I'm raising it because of the discussion regarding that place called Portmore. So just in the event you may...
I'm trying to say that great place called Portmore.
Okay, that great place called Portmore. So you may pass this into law and then you may realize that you now have appropriate facilities in that great place called Portmore. And for you to now put Portmore in the list, you would have to go through the long process of amending the act. So I'm wondering though if there was a policy decision why the fourth schedule was omitted, because it seems deliberate. So I don't know if the thinking was that there shouldn't be an easier amendment method. So it may be good before you take a decision just to understand what the policy was to inform the provision.
You know, the fourth schedule ends and any other office of the Firearm Licensing Authority. So if you just made it and any other place as may be designated by the minister. Because I don't even know if this has to...
Just to say though...
To be subject to affirmative resolution. I think, you know, just designating which police stations would qualify. I think that is something that can be left to the minister to determine and publish in the Gazette.
Because the minister had said, Chairman had said, it had the consideration turned on the extent of the armory and the what is in place
and I'm not,
for safekeeping. But the
understand.
point about any other place for designation, because those
from time to
considerations
time,
for
those
safety,
things will change, and if stations will be upgraded, new stations will be built, etc.
And the SG's point about the abridged amendment version should be taken into account too.
Right, but I'm suggesting I don't even think that needs affirmative resolution of Parliament.
I think the distinction was being made between the police stations and what would be under the FLA's control, which is why they're set out.
I understand, but I think it's a distinction without there being a real difference. And I'm saying since the determination will be made based on the facilities available, which is something that will change from time to time as we build new stations, as we upgrade stations, etc. I think we can just leave that to be designated, you know, when they qualify to be so designated.
There is no harm. Yeah.
No, that makes sense, because we are building new stations and opening offices all over.
Point is well made and taken and can be reflected in the report. Yes.
Yes, Chief.
Just to confirm, Minister, that the policy was to exactly exclude the fourth schedule from that provision, from 106, so that it would not be subject to affirmative resolution. So the point is now taken that probably what we could do to expand the fourth schedule, that instead of prescribing specifically firearm licensing authority at the ending of the paragraph, that we say any other place, as is designated by the Minister.
Just to clarify, so the point made by the Learned Solicitor General is not misunderstood. When the amendment is permitted to be done in that way by regulation submitted to, subject to affirmative resolution, it's a shorter process. Otherwise, if you have to amend a provision, be it a schedule or any other clause, then it would have to go through a bill and the long process of amendment. So just so that that point is not lost.
So that point is not lost. So the point we're making is that we do not want it to go through that process. What exactly needs to happen in this specific case is that the Minister will designate it by notice published in the Gazette, meaning that his authority would not be subject to affirmative resolution. It doesn't have to go through the parliamentary process.
So this would be the express.
So if you didn't want it that way and outside of any other place, which would capture an additional police station, it would have to go through the long process of amendment. No, if the second part is amended to include any other place, then it's okay. The Minister will do so by, you know, its assessment and then designation and notice in the Gazette. Okay.
We're all clear. We're all clear.
Surrender of license, firearms, and ammunition. The holder of a firearm user's license shall, if the holder wishes to surrender the license and deliver all firearms and all ammunition to which the license relates to an employee of the authority authorized to receive them or to the sub-officer in charge of the police station nearest to the place where the holder resides. 81, storage fees, release of firearms and ammunition from storage.
Sorry, Ms. Grant. In 80, is there in the event that what is required there is not done? I didn't see any sanction, or am I missing something?
Remember, this is where the holder volunteers to surrender the firearm.
Okay.
Therefore, there would have been no penalty attached. This is on his own volition.
(81.1) Where a firearm or ammunition is delivered under Section 79, A, the firearm or ammunition, as the case may be, shall be released to a person who produces a firearm user's license granted to that person in respect of the firearm or ammunition, as the case may require, and B, if the firearm or ammunition is not released in accordance with paragraph A within 12 months after the date of delivery or surrender, 1, the owner thereof shall be liable for payment of a storage fee in such sum or at such rate as may be prescribed, and 2, if the fee is not paid within 6 months after the expiration of the aforementioned period of 12 months, the firearm or ammunition or both, as the case may be, shall be forfeited in accordance with Section 96.
Question for you, please, CPC. At A, and I'm not sure what the practice is now, but if the only place I can deliver the firearm or ammunition is to the FLA or to the police, what's the license status? Why are they required to have a firearm user's license? If the person is authorized at the FLA or there's it's a constable, a sub-officer in charge of the police station, I'm trying to understand what is the purpose of who produces it. Why do they have to produce a firearm user's license to me? Aren't they the authority grounded in law to accept firearms and ammunition? It almost seems to me to harken back to a provision that would allow for you to give it to your friend. So I'm wondering if we should have that in there.
No. All right, let me explain. Member Cousin raised a very important point earlier about license holders holding other license holders' firearms. It is because of a misinterpretation of the section in the Firearm Act, the current Firearm Act, that says the person is allowed to hold the firearm if he's a license holder for that particular firearm. Now, it gives the impression that if you have a 9mm firearm, you're allowed to hold for another person another 9mm, and it's a real belief of the public, and so it happens a lot in the public space. So what this is saying, for clarity, we do allow a firearm, a person, more than one person, to be licensed for one firearm. So if you, Member Golding, should have a license for your firearm and leave it at the FLA, the only other person could collect it is either you or somebody with a license for that particular firearm to collect that firearm from the FLA. That's what we're saying. So you have to produce a license to be able to collect that firearm. That's why it is placed like that.
I just caught my error, yeah. I'm looking at it in terms of delivery, not release. Thank you. Understood. Agreed.
81.2, the fee referred to in subsection 1B1 shall be payable to the authority. 82, delivery of fire.
Just 1 second. Does that mean 81.2 specifically relates to the authority, but the 81.1 entire deal with fees? Are the police stations authorized to collect fees?
No. What is proposed there, member, is that the collection by the police would be as an agent of the FLA. It is for convenience for the license holders, really. But the book and the receipt that is used is a FLA book that would be used. So it would be deemed to be in the FLA's custody nonetheless.
No. Clarify that for me. So, okay. So when the John Brown takes it to the police station, yes, listed in there, are they taking it on behalf of the FLA?
That's the intention, Mr. Chairman. Let me explain.
The intention.
Yeah, let me explain why.
Exists.
Let me explain why. What currently exists now is a hybrid situation, because prior to the FLA's formulation, establishment in 2006, the police had the remit. So because of convenience, so if you're leaving the country in the night and the FLA is closed, the closest place to you is the police station. So the convenience of you leaving it at the station, we didn't want to remove that. So that is why the hybrid exists now. So what we have done now is to put it in law.
Formally.
Right. And the FLA would still have possession of it when you leave it with the police station, because the book that is being used, the receipt book for storage, sorry.
So therefore, the question that arose earlier on about Member Bunting that asks a prescribed form, that would become redundant under this act.
No.
If the police station is acting on your behalf, I take it that you will issue them with the requisite forms to receive it.
That is correct.
So the prescribed form would become redundant?
Not really, because it still would be prescribed, or it is received.
No, I mean a prescribed form for the police station, because they are now acting on your behalf under this new act.
What Member Bunting was saying is that whether FLA or the police station, it should be a prescribed form. That is what I understood him to be saying.
No, that is in the absence of them having any form, because you had said you do have a form.
Yes, but it's not a prescribed one.
Uses.
But it's not a prescribed one. Member Bunting was saying.
One, but it's not prescribed.
Right.
Okay. And you were suggesting that it should be a prescribed form
I would agree,
rather than just a form.
I would be agreeing with that. Okay. Yes.
'82, delivery of firearms and ammunition to appropriate.
Before you go ahead, I was a little confused by what Mr. Darling said in relation to 81. I got the impression that what he was saying was that more than two persons, like you could give more than 2 persons could have access to the firearm. But here, only 1 person can have the license. One can have a permit. And Section 81 specifically says the person must produce a firearms user's license. So I just wanted a little clarification on that, because it doesn't seem to me that anybody else but the licensed firearm holder can actually collect the firearm. And might be how the clause is worded is a little bit, because it says anybody, it shall be released for a person who produces a firearm user's license. Maybe it should be the firearms user's license, to make it explicit that only the firearm user's license, only the licensed person can collect it.
Right.
I don't know if that's what you said was accurate.
That's
what I'm seeking clarification.
All right. Let me explain again. The current legislation refers to it as a firearm user secondary certificate. Under the current construct, we have a person having a user's license. So you can give 1 person. So for argument's sake, member, your son may be issued a license authorizing to carry your weapon. So, no, yes, right. Let not confuse the word. Let me use it. Current legislation refers to the secondary certificate, which is what will be issued under this new legislation, a certificate. So if he produces that, member, he is authorized to collect the firearm because he's a secondary holder of that very firearm. You are the primary holder.
Mr. Darling,
yes.
that don't sound like what we intend, you know. No, so go ahead, Mr.
Sorry.
Richards, through you, Chairman.
Sorry, I think Mr. Darling no, I'm not going to use those words, Minister. I think he's speaking to what happens now in practice. And I think that the provision as it is written, well, maybe for me it is quite clear. So it says, so the firearm user's license must be granted to that person in respect of the firearm or ammunition. So it has to be to that person who is coming to collect that firearm. And that person must be the firearm user, must have the firearm user license.
Right, and that was my understanding. So it was also my understanding that the only person who could actually collect the firearm was a licensed firearm user.
Exactly. Just a question here, Mr. Chair. Following upon my colleague's inquiry here. So, am I to understand, or are we to understand that Section 81(1)(a) is restricting the collection of the firearm to the person who holds the firearm user's license in respect of that particular firearm? Is it a single person? Is it the definite article? Meaning, so are we to say, when it says here, a person, we're supposed to delete the a, because a is...
Because that's what you were saying.
Okay. Member, there is a firearm employee certificate, for example, that the principal holder has that firearm. You would not issue, if the principal leaves that firearm, you do not issue that to the employee. However, as I pointed out in the member's case, where the member has a license for the firearm and the son has the certificate to carry that said firearm, which is a single unit in terms of a home. So the member could leave her firearm with that individual if out of the country at any time. But in terms of storage, I'm wanting it to be clear. Are we saying when it's left in storage, it is only the principal that can collect it and not the secondary holder?
We're not reading it. We have to read it in conjunction with 79, because it's a firearm delivered under 79, where the licensee wishes to make temporary storage, to make arrangement for this temporary storage or custody of the firearm. So if you look at the chapeau at 81, it says where a firearm or ammunition is delivered under Section 79. right? So this is not at large. It's that firearm and that firearm licensee who made arrangements for the temporary storage and custody of the firearms, either at the police station in accordance with the schedule or at the FLA office. So that is where now the retrieval relates to.
Right, but I guess the question is, why would you want to prohibit the firearm user's secondary certificate person from either submitting it for storage or retrieving it from storage, since they have a user's certificate for that firearm?
So, Member Minister, having heard what Mr. Dallin has presented in terms of what happens in operations, I think that we ought to probably look back at this provision just to make a provision for the secondary users, for the secondary
Question ask whether or not, since more than one person may be authorized, but remember the license is one form of authorization. So you have the permits and the certificates that follow. And once the firearm is registered and there is a lawful possession and holding around it, it may make sense because you can still trace it.
Right, but as it is now, it really just speaks to the firearm user's license. So I think for the avoidance of doubt, for the purpose of clarity, we will make reference
But
to
it was not my understanding as part of the policy that a firearm, say the security guard to whom the employee certificate is issued, could go and put in a firearm for storage outside of the licensee. So we also have to be careful that we don't open it widely. So that was never the intention at all.
But I'm sure in a big firm where there are hundreds of licenses and users permits, for example, it's not the principal of the firm who is every time going to go and surrender or retrieve from storage. So, you know, you would have supervisors, etc. So I think it is as a practical matter. I think we could expand it to say that any who has the appropriate firearm authorization for that specific firearm.
I think the point is generally accepted, and we know where we don't want to go so wide, and it shouldn't be as narrow as it is. So it could be looked at. Yeah.
Thank you, Minister. We're going there because I know that at least one security firm had to close down because the principal died.
Chairman, as long as we are not breaching the policy, because there is a traceability and who to be held accountable.
There has to be what the Prime Minister calls some framework.
So the policy question is who would be authorized to put a firearm in storage and who would be authorized to retrieve it from category of persons.
And it has to be some other responsible.
Yes.
So. We'll try to give the House time.
Let's do 82 quickly.
Let's try and get to 82.
82. Where the Minister is satisfied that it is necessary for safety or in the interest of national security, the Minister may, by notice in accordance with subsection 2, require the delivery to the authority of such firearms and ammunition as may be specified in the notice, subject to such terms and conditions as may be specified in the notice. 2, a notice pursuant to subsection 1 shall be published in the Gazette and once in a daily newspaper circulating throughout Jamaica. And upon a notice being so published, any person to whom the notice applies shall, within the time and in the manner set out in the notice, deliver any firearm and ammunition to which the notice relates to the authority for safekeeping. 3, any person who, without lawful excuse, fails to comply with the requirements of a notice given pursuant to subsection 1 commits an offense. 4, where a constable has reasonable grounds to believe that a person is, without lawful excuse, in possession of any firearm or ammunition in contravention of a notice issued under this section, the constable shall, pursuant to a warrant issued by a justice of the peace, retrieve the firearm or ammunition, as the case may be, and deliver the firearm or ammunition to the authority for safekeeping. 5, if a person commits an offense under subsection 3, the firearm authorization in respect of the firearms or ammunition concerned in the notification shall forthwith be deemed to be revoked.
Could you, I don't understand the intent of this section, because this is apparently not applying to somebody who would have their license or authorization suspended, revoked, or cancelled. But this is where it is for safekeeping. I'm just trying to understand. Give me an example of where this would apply rather than 83 or that the section starting with clause 83.
Okay, so, Member Bunting, a practical example for it would be if there is intelligence that suggests that there might be that a dealer might be in jeopardy of his place of business being robbed, then the minister may, utilizing that intelligence, ask for those firearms to be delivered to the authority. Or it could be a case where there might be a natural disaster that is pending, and in discussions with technical persons, he would make that decision for the firearms to be brought in for safekeeping.
This is specific to dealers, you're saying? Or this is
just an example.
Sorry?
I'll just give an example using dealers.
So, for example, the minister might say a hurricane is coming. All licensed users bring in your firearms?
I should hope that the minister wouldn't be so frivolous as to utilize this provision.
No, but why are you creating you're creating a power and then hope the minister doesn't abuse it? I'm just trying to understand the specific circumstance, because if it is a dealer who you are concerned may be under threat.
Member, it is cast deliberately broad. This is not to say it can't be reconsidered, because it's in the interest of safety and national security. But in respect of whom it applies to, a notice would be given, and then persons would have to comply. So it's by notice, require the delivery to the authority of the firearm or ammunition specified in the notice on whatever terms and conditions that may be specified.
So what I'm saying is, we know that this minister, for example, has some very conservative views on firearm licensing. He may very well say that it's in the interest of public safety for every licensed firearm holder to surrender their firearm. This clause gives him that power. And the 40,000 or however many would then have to, once he publishes it, surrender their firearms. I think this is a way too broad power.
What language would you suggest to narrow it?
Before I suggest the language, I'm just trying to understand what it is, the circumstances or the scenarios that it is anticipated
Well, you got one.
to address. Well, if it is the one I got...
If disaster strikes and storage places are destroyed, and then it becomes easy for others. So, for example, when hurricanes happen or earthquake, you see many times in the news people go and loot properties because the premises are no longer secure and everybody is at large. The provision is intended where there is reason. So, in safety reasons, national security reason, that the power can be exercised.
But that power is with relation to storage, whether by dealers or whomsoever.
So let's look at what it says again. It says where the minister is satisfied that it is necessary for safety or in the interest of national security, the minister may, by notice in accordance with subsection 2, require the delivery to the authority of such firearms and ammunition as may be specified in the notice, subject to such terms and conditions as may be specified in the notice.
So I'm
That's
saying
one.
it's so
and
broad.
The notice.
He could recall every firearm licensed firearm in Jamaica.
You know, Minister, I think part of the challenge that we have in this jurisdiction is that there's probably a lack of understanding from a public administrative law perspective of the principles that guide the exercise of statutory duty. And I say generally, because where I'm coming from in the chambers, we see so many. But there are actually very clear principles around the exercise of statutory duty. Matters in relation to national security are traditionally given more latitude because of the defense of the realm. Doesn't mean though that there aren't proper bases on which any power given is to be exercised. But what you have in the traditional line of case authority is that if the court, something is brought into question which relates to national security, the court usually gives deference to the executive branch, which would have more information than the judicial branch in the exercise and in the exercise of its powers. And along the review spectrum, in terms of judicially reviewing decisions that are taken, there are a number of cases which tell you where you will have more review, less review in respect of how you examine. I'm telling you, don't laugh, it's what the case law says. You may not be aware of it, but it is what it is. So I'm saying to you that what then would be your suggestion, since you believe that as widely cast as it is, an errant minister may do something that is not intended?
Before Senator Bunting answers that question, if I want to have a sense, so the notice is published, it's circulated in a newspaper and gazetted, and this notice might, for example, name a particular person who is required to bring in their ammunition and their firearm. I'm not clear, and I'm also not clear how it is in the interest of a national security or safety that you have this vast publication of, because it says here, it shall be published in the Gazette at once in a daily newspaper circulating through Jamaica, and upon a notice being so published, any person to whom the notice applies. So you're actually giving everybody notice of this national security issue involving a particular person. It seems odd to me.
Not necessarily, so it may be... But I understand your point.
You see, no, not necessarily, but I want to look at the possibility that it might, in fact, be a danger to national security and to safety, that this methodology be chosen. So if I can just understand it.
Madam CPC wants to come in through you, Chairman.
Yes, thank you. I just wanted to point out that this is currently an existing provision in the Firearms Act, Section 35A, and I know that in the past notices have been given on utilizing this provision.
Could you give us an example of those notices?
Well, one that I can recall had to do with where a person's authorization had been revoked, but they had not surrendered the firearm and ammunition. And so a notice was issued. And in fact, the firearm and ammunition might have been in the possession of somebody else who was not even the firearm holder whose license had been revoked. So a notice was published in the paper requiring all persons who were in possession of the firearm and ammunition to which a revoked license related to hand over the firearms and ammunition.
But that's a very different situation than what Mr. Richards had spoken about. Because this published in the newspaper and thing before the hurricane arrives, I anticipate great confusion with everybody trying to bring in their thing in the last day or two of a hurricane. And then there's a separate section to deal with issues like suspension, revocation, and cancellation of authorizations. I don't want to keep the committee away from lunch, Mr. Chairman, but if the officials could provide us a little better brief on for the next meeting or for a future meeting, so just so we can understand. And what I do find is that a lot of these clauses or sections that come forward from old versions of the Act put a lot of power with the minister. For example, some of these things go back to pre-World War II, and it probably contemplated the minister, having intelligence of German agents in the island pre-World War II, and they may have required all Germans to surrender their firearms, or something like that. I'm just speculating here of why the original, but the circumstances may have diverged dramatically from that, and the best practice nowadays is to circumscribe much more narrowly the power of the executive as opposed to,
Member Jackson, I don't know if the senator says here, disarm the site, you're just calling all the arms.
No. I was just wondering, Chairman.
I was wondering if the senator's approval, they were just calling everything.
This is a backdoor for you to do exactly that, to disarm the society, or at least disarm the law-abiding citizens anyway.
No, I was just wondering, Chairman, if using the scenario that the minister indicated of someone by virtue of intelligence is deemed a threat to national security, I would think that with that information, which is the evidence or information, is one in which the police will come into being. So I'm contemplating that in such circumstances, it is the Commissioner of Police who would be interfacing with the FLA. Because you have a specific...
It's not difficult. I mean, if it's intelligence, that's a security issue which the police would deal with.
Yes. Why the minister would come into that?
No, I'm saying... go ahead,
Chairman, I think we run the danger of looking at the running of government too narrowly. So that executive has, a minister is assigned subject matters and portfolio constitutionally. All right, and ultimately has, through the cabinet, for policy matters and general direction, matter of national security, matters of public safety, those are defined subject matters that are assigned. And then you have laws and you have agencies, you have departments that perform functions in relation to those subject matters. So, I think part of the reckoning that we need in this society is because what we've had examples and so much speculation around what gets into the database as intelligence and then what is acted on. Because we have heard so many examples of mischief, and there is then a fear that something that is totally unsubstantiated may have been placed before persons with a view, maliciously or otherwise, to be acted on. But we have to, while I totally agree that in making provisions for powers and the exercise of powers, great care must be taken, we also have to equally take great care that we don't emasculate government.
I was just simply saying, Minister,
right?
Matters of national security, where intelligence is available, that's not a policy issue. That's an operational issue.
No, remember, the clause stated
here. It can span both. It can span both, Member Jackson. They don't neatly fall in that divide at all. They don't neatly fall in that divide. Under our law, we have said that a minister is not to be engaged in operational matters, except the Minister of Defense, under the Defense Act, does have some power in respect of the JDF and deployment of the JDF. And that's in the law.
I don't think there's any confusion in this particular clause there. Remember, if you look at where the intent would come in more in relation to 82.4, not the minister constantly go and find a warrant and retrieve the firearm, etc. So those are issues, operational issues, be quite clear, I think, in the
Chair, if I might just raise two issues in relation to this, because I'm seeing some difficulty in relation to one. If this clause gives the power to the minister to publish this notice requiring a person to deliver the firearm and ammunition, one, the person who, without the person who fails to comply with the requirements, and I don't know if a lawful excuse can be, I didn't see the notice, but I'm concerned that we are allowing notice by publication. And I'm talking about in a scenario, we're talking about a single person or a few persons. We're allowing notice by publication as opposed to notice by service. Why shouldn't that notice be actually served on the person? And there may be scenarios where that is not possible, but I just want us to think about it for a minute. If a person or persons are aggrieved by that publication, if the minister is the one directing it, I fear that we fall into a similar category as was raised in the previous committee meeting in relation to who is the remedy for that person who is aggrieved by the action of the minister directed at. Is it directed at the cabinet? Is it directed at the particular minister? The minister? But you can't sue the minister.
It happens all the time. A minister is named in a suit alongside the Attorney General. All the time.
But the decision, okay, so where do we fall in terms of the discussion of let me finish the point. Where do we fall in relation to the discussion where the minister's power is a part of the collective cabinet? That's where I'm kind of feeling a little troublesome here, and I'd be grateful for the clarification. But so my 2 points was a question of notice by publication versus notice by personal service, and my second point was a question of who's the remedy against. If I could get some response to that, I'd be grateful.
I just wanted to point out that this would be a situation where you'd apply for judicial review of the minister's decision rather than seek to bring an action. And I think that the provision is seeking to deal with a situation where personal service would not be practicable. If there is a threat of a nature that the minister needs for this information to be widely published, circulated, brought to everyone's attention, it may not be one that I don't think it is intended to deal with that routine type situation where personal service is possible.
And so this power is necessary only in the interest of safety. It's necessary for safety, and I'm assuming that means public safety. Do we need to say that? I don't know. Or in the interest of national security. In other words, safety of whom? Safety of my next door neighbor if I'm the one with the firearm, or public safety? Yeah, thanks.
Thank you. We'll reconvene tomorrow. I'm going to ask Minister of Justice to chair, and we'll do it hybrid tomorrow, Minister. Huh? What's that? Yeah. And what we're telling.
Conclude reading the section. Is a mistake, we
Did you say the Minister of Justice, Chairman?
Then I realize you're having the same challenge I was having to, Chairman.
I just want some clarification. The Minister of Justice is a member of this committee?
The Minister of Legal Affairs.
Oh, I see.
I'm more comfortable with that. It's certainly better for the optics, isn't it?
I am comforted that I'm not alone.
So mischievous.
Hybrid, yeah.
In person.
In person. Virtual. Right. So tomorrow we'll do in person, Thursday we'll do virtual and start the virtual process. Right.
So move for
the
your
meeting be
adjournment.
adjourned.
Second.
Tomorrow morning at 10.
Tell me something. How much time you ever hear the government announce a project and wonder why they must spend millions